Good afternoon, friends and colleagues. Welcome to our third session of Know Your Tribunals. Nick, can you hear me?
Yes, I'm present.
Okay. Karibuni sana. This is a series that we're doing in line with the role of the branches. We're doing it in partnership with the MLS branch today. And we hope that in the near future, we'll be able to incorporate all the other branches to do this together. That is the vision that MLS and myself, part of the Nairobi branch, carry. Carol, would you please add, I'm getting a number of calls from members that they're unable to join. The link is full. Would you please add members to the session if possible?
Okay, working on it.
Okay. So my name is Efi Shilachia. I convene the Social Welfare Committee of the Nairobi branch. I am going to be your co-moderator alongside my friend and colleague. I will allow him to introduce himself. Mukanzi.
Thank you, Efi. My name is Titus Mukanzi, a member of the Mombasa Law Society and equally a member of the LSK Coast branch. I'm delighted to be present to co-moderate with my colleague Efi. Later on, we shall introduce members of the MLS Council present, including my chairperson. Thank you.
Thank you very well. I don't know whether the chair of the branch is present. Before I go to the speakers of the day, I see you, Chair. Chair, the floor is yours.
Thank you, Madam Welfare Secretary. I am indeed present and really delighted. I must say that Brother Titus Mukanzi, together with your chair, we are enjoying the collaboration and are happy that we are able to jointly undertake activities. I must say that it has been quite a delight, and I want to thank you, Madam Welfare Secretary of the branch, for putting this together. And this is very much in line with what we promised our members, that we will be pointing them to places where we can expand our practice, so that the notion that there is not much to do for the new members joining the profession is debunked. And so I want to welcome all our members from Mombasa and those from Nairobi. I also know that we might have members from other branches. We welcome you to this session that is going to point you to directions that maybe you did not know exist. Thank you so much. And once again, asanteni sana Mombasa branch for this collaboration. I look forward to an illuminating session. Thank you.
Thank you very much, Chair, the branch, Nairobi branch. I don't know whether the chair of MLS is present or she will be joining us much later. Mukanzi.
Let's see if chair is present. If my chairperson is not present, I will call on my Deputy Secretary General, I've seen Boaz around, to give remarks on behalf of chair. Adara seems not to be on standby. We will proceed, but allow me to recognize the presence of my fellow council members, Mr. Boaz Adala, Deputy Secretary General. I've seen Sharon Shisia, council member, and possibly the rest will be joining as we proceed.
Very well. On my end, I am not sure whether the council members from Nairobi branch logged in. If there's any council member, I can't seem to see you on the link. Just let me know on the side and I will get to give you a chance to say hello. For those of our friends who are unable to join, the link is full, but we'll be creating a space as and when to add our friends who are waiting on the link. I think from now on, we just proceed to the speakers. First on the list is none other than Honorable Hilary Korir. Honorable Hilary Korir is an advocate and a CPSK, admitted to the bar in 1997. He's worked as legal officer with NHC between 1998 until 2006, when he was appointed as the chairperson of the Rent Restriction Tribunal to date. Honorable Korir, if you can hear me, please unmute, and if you can also turn on your camera. I think my colleagues would want to see you to put a face to the name.
Okay, good afternoon, learned friends.
Good
Do you
afternoon.
hear me?
Yes, we can.
Good afternoon. Caro, is that Effie or Caro has stated, my name is Hilary Korir. I chair the Rent Tribunal. It's good to be here. Good to see all of you. Looking forward to an engaging and a fruitful discussion. Thank you.
Thank you very much, Honorable Korir. The next speaker is Honorable Desma. I think we've had some time with Desma again. This is a second time I'm hosting her, if I'm not wrong. Honorable Desma. I will read her. She has a very long CV. So she's married with 3 children. She was born in 1979, okay. Has an LLM from the University of South Wales, an LLB from Moy University, and a postgraduate diploma in 2004. In legal practice and experience, she's a founding partner and head of litigation and alternative dispute resolution of Now Advocates, formerly Nungo, Odur, and Waigo Advocates. She was an associate advocate at Rachier and Amolo. She is the chairperson of the Political Parties Dispute Tribunal. She has done several community and public service pro bono activities. She's a member of the board of members of Langata Boys High School. She's a member from 2018 to 2021, a member of the BOM and chairman of Integrity, Discipline, Welfare, and Ethics Committee of Bishop Okoth Mbaga Girls Secondary School. In 2010 to 2024, she undertook collaborations and partnerships with Now Advocates, LSK, Kenya School of Law, Kelin, Awesome Blossoms, ANAA Foundation. And I think if I were to read her CV, I would be taking the better part of today's session. Mhesh, karibu sana to the session. Please feel free to introduce yourself and tell us one thing that is not in your CV.
Asante sana, Effie, and it's a pleasure once again to be here. Good afternoon to you all. If you're on a late note, you are to exercise your discretion and only read what was necessary. But nevertheless, I'm glad to be here. And I'm just looking forward to engaging with the team. Perhaps I will engage more as we proceed in the interest of time. Thank you very much.
Thank you very much, Honorable Desma. Before I bring in my co-moderator to introduce the last speaker, Honorable Desma, you've not told us something about you that is not in your CV, that we need to know about you.
There's really a lot that is not there in terms of my personal life, and maybe depending on how discussions go along, Effie, we might open up more on that other aspect. Kindly for now, thank you.
Very well.
Just a second. Thank you, members. I'll take this time to introduce our third panelist, and this is Honorable Gakuhi Chege. Honorable Gakuhi Chege is an advocate of the High Court of Kenya. He has practiced as an advocate with passion for the past 32 years. He is a member of the Business Premises Rent Tribunal. He has served in the capacity of vice chairperson from the month of June in the year 2020. And in this capacity, he has served on a part-time basis. Mheshimiwa insisted that we also mention that he is a family man. Welcome, Honorable Gakuhi. Maybe you can say a word to the participants before we commence.
Yes, good afternoon, all my colleagues and also my fellow panelists. I am delighted to be here on behalf of my chair, Honorable Cyprian Mugambi, who thought that I can be of some use in this discourse while trying to understand what we do here at the Business Premises Rent Tribunal, where I have been since the year 2020, as has been ably put by the moderator. I look forward to a very engaging moment for the few minutes that we have. Thank you so much.
Thank you very much to our speakers. I think we'll just go straight to today's topic. Allow me to just refer to all of you by the name our speakers. So a number of young advocates are logged in today, and they're saying we are used to, if you can kindly mute. Thank you. We're used to the normal court sessions, civil and criminal, but we've never appeared before a tribunal. Perhaps in the order in which you introduced yourself, would you kindly take us through what is the jurisdiction of the tribunals? I'll begin with the first, Honorable Hilary Correa.
Okay, very well. Thank you. Thank you so much, Madam Effie, for that question. The jurisdiction of the tribunal has to do with the resolution of disputes between landlords and tenants of protected properties, which have been defined under the Act to be those with rent of a minimum of 2,500. We deal with issues to do with eviction, to do with proclamation, illegal proclamation by the auctioneers, matters to do with disconnection of services by the landlords, and most of our matters here are filed actually by the tenants. Going to, in our estimation, it's about up to around 70% or 80% are from the tenants. The kind of mix-up that we get is between, there's another tribunal for business premises as opposed to ours of residential. So we get matters coming which are both residential and commercial within the same premises, and that creates jurisdictional misunderstandings, which sometimes we are forced to refer to the right tribunal. I believe I've said so much on the jurisdiction, Council.
Yes, you have, Honorable Hilary. But perhaps let's clarify what makes your tribunal different from mainstream courts.
Very well, tribunals are known to be simple and less technical and devoid of procedure, and they are supposed to be fast in delivery of justice. I guess that those are the three major distinctions. The third one being that they are also specialized in a particular area, which is the case, in our case, is residential premises.
Well,
good? Yes.
Yeah, that's good enough for starters. Honorable Lungo, we're going to 2027, so please inform us.
Thank you very much. As I start, allow me also to thank both the Nairobi branch and the Mombasa branch and the entire leadership for this opportunity to speak about the Political Parties Disputes Tribunal, where I currently serve as the chairperson. So in terms of an understanding, Political Parties Disputes Tribunal, normally in short, we refer to it as PPDT. I'm saying it as simple as that because I appreciate that there could be young lawyers who are also present and they may be hearing phrases PPDT and will be wondering what exactly that is. So PPDT, our parent statute is the Political Parties Act. The establishment is under Section 39 of the Political Parties Act, basically with the mandate to hear and determine disputes involving political party affairs. What you need to know is that in terms of our composition, the tribunal is composed of 7 members, that is including the chairperson. So we've got the chairperson, and then we have 3 members who are lawyers, meaning from the legal professions, and then 3 members who are non-lawyers, but from different areas of expertise, just to bring in the rich mix of skills within the tribunal. Now, in terms of our jurisdiction, it's out clearly in Section 40 of the Political Parties Act. You can go through it at your own time, but basically we hear a series of disputes. But even before I got there, let me just clarify that the composition of the tribunal changes during the pre-election dispute resolution period, more so about a year or so to the receiving of complaints before the PPDT. And this is associated by the fact that the PPDT gets busier handling nomination-related disputes at that pre-election period. So the composition therefore changes so that in addition to the 7 members that I have mentioned that serve for a period of 6 years, we also have what the statute calls ad hoc members, and these are usually a total of 18 additional members that are appointed to serve together with the 7 members, giving it a total of 25 members. So meaning, therefore, that in that period, we're able to hold many panels. Ordinarily, we can only do any 2 panels at a time, given the 7 number of members, because the minimum number of members to sit in a panel is 3. But during elections, we're able to do 8 panels running across the country, and we'll be discussing more subject to the availability of that opportunity later. So what kinds of disputes do we handle? As I mentioned, they are set out in Section 40, basically concerning political party affairs. In simple terms, parties bring in disputes, for example, revolving around restructuring or going on within political parties, be it the issues to do with the political parties changing their constitutions, are the provisions they're introducing okay, are there changes in the officials within political parties, is it done in a manner that goes with the constitutions? And of course, you many a times, even in the media, hear instances where issues to do with changes in officials, especially key positions like maybe Secretary General or what have you, attract a lot of disputes where you have even a party having different factions. Those have been open in the media, so those are the kinds of disputes we handle. We handle disputes involving party discipline, where political parties are disciplining their members, but perhaps maybe in the process of doing so, there are certain lapses that they happen that call for legal attention. A party that is aggrieved is at liberty to come before the PPDT, including even decisions party make, like, for example, expelling their members. These are common in the media. We get to hear them each and every day. Parties who are aggrieved by such processes are at liberty to come to the tribunal. The tribunal hears disputes relating to party nominations, disputes relating to party lists, disputes also relating to coalitions, whether it's a matter of leaderships, disputes relating to even matters to do with changes, where political parties are making changes in their leadership at various county assemblies. We also hear appeals from decisions of the registrar of political parties, and we also have a review jurisdiction. So probably I'll be breaking them down more as we move along, but that's just an example. In a nutshell, any dispute revolving around political party affairs are subject of determination before the PPDT. All you need to know is that there are those particular disputes where before you come to the PPDT, the parties must first exhaust the available internal dispute resolution mechanisms within their party structures. So this is what in PPDT, anyone who practices in PPDT, you'll always know the phrase IDRM. It applies, it's been used many times. That basically just comes to internal dispute resolution mechanisms. So those are the kinds of disputes. Now the last or second last bit of it is the cases that are maybe people bring before the PPDT that should have been directed elsewhere. Maybe what I need to be clear, because this forms over 90% of objections that come before the tribunal. I'll again speak to the question of IDRM. Many a times, parties or litigants move very quickly immediately upon the occurrence of an event, and then they run to the tribunal to file their disputes without showing any attempt to pursue settlement outside the tribunal in the first instance. So that raises a jurisdictional issue, and many a times matters have been directed elsewhere so that they are attended to within the party structures. Other misdirections or other jurisdictional misunderstandings that we can speak to later is, for example, during the nomination processes or during the nomination period. At what time does the PPDT, for example, stop hearing and determining disputes? Remember, our role is performed. There are also other actors that are in the space of dispute resolution. We have the IEBC, and I believe many of you would appreciate that the IEBC, they have a dispute resolution committee that also deals with matters nomination. We've also got the courts and the appellate processes within the courts. So where, for example, a party has been gazetted, then jurisdictional issues step in. There are also jurisdictional issues concerning constitutional and human rights issues. Given time, I would speak to the different schools of thoughts and the limitations therein. And of course, there are also jurisdictional issues between IEBC in itself and the High Court. So maybe just to leave it there for now, basically those are the kinds of jurisdictional misunderstandings that we may experience. In terms of how our tribunal is different from the ordinary court, I think my colleague, Honorable Hilary, has captured it well in terms of the simplicity, the specialization, the expeditious, and also in addition for the PPDT, the collegiate, and I think also other tribunals, because it is not just one party who sits to hear and determine a matter. It is a minimum of 3 for PPDT, so there is therefore that rich engagement in terms of just ensuring that a dispute is looked at from all angles. So thank you, Sheila, for now. Maybe I'll step in once directed again.
Thank you very much, Honorable Desma. Lastly, Honorable Gakui.
Oh, thank you, Evie, for giving me once more this opportunity and also for allowing us to come and market our various tribunals. This tribunal, known as the Business Premises Rent Tribunal, is a fairly old tribunal. It, from the content of the Act, that is the Landlord and Tenant Shops, Hotels, and Catering Establishments Act, 1, the tribunal was first established in 1965, and it is established under Section 11 of the Act. It is a statutory tribunal, which is quasi-judicial in nature, and it is created to manage disputes between landlords and tenants in business premises. Those premises specifically attract disputes like issues with arbitrary rent increases, unlawful evictions from commercial premises. And basically, it is intended to protect tenants from exploitation by landlords based on public policy to safeguard especially the small traders. The composition of the tribunal is to be found in Section 11. Members are appointed, or it can be constituted of one member or more persons appointed by the Cabinet Secretary. But recently, in line with the interpretation of the Constitution of Kenya 2010, this power to appoint has been interpreted through the judgment of the Court of Appeal in Attorney General versus Okia Omutata Okoit and 3 others, 2025. You will be able to see it into bracket, Kenya KECA 309 into bracket Kenya Law Reports, which was delivered on the 21st of February 2025, that power to appoint has been now vested in the Judicial Service Commission based on the interpretation of the law. And therefore, members of the tribunal will no longer be appointed by the minister. We who are now currently sitting were actually appointed by the Minister of Trade, but that decision also affects all the other tribunals, because the interpretation is that tribunals are actually a creature of the Constitution, Article 169, 1D, which actually says that local tribunals actually are subordinate courts. And therefore, the interpretation is that based on the separation of powers principle or doctrine, the executive cannot be the one to appoint judicial officers, and therefore the power to appoint is now domiciled in the Judicial Service Commission. And I think that is also so for other tribunals, because I understand that there is even a freeze that any appointments that are being carried out by ministers or cabinet secretaries are not being approved by the judiciary, and the new members are not being sworn in to continue with the jobs for which they have been appointed until they are vetted, even where the Act does not provide so. In practice, the tribunal is chaired by an advocate, and in fact, currently we are 10 members, 2 of whom are non-lawyers. All the other 8 are lawyers. For the non-lawyers, they sit with a lawyer, and we therefore have 8 courts, meaning that we have each member who is not sitting with a non-lawyer sits alone and has capacity to make decisions without being in a panel. Perhaps I could also indicate that this tribunal has several branches, that is regions. We are in, the main headquarters is in Kenya Re Towers, where we have shared services here in Nairobi, but we have regional offices in Kakamega, Kisii, Kisumu, Eldoret, Nakuru, Nyeri, Embu, Meru, and Mombasa, in line with Article 48 on access to justice. We do virtual sessions. All our hearings are virtual, and therefore we are easy to go. Anybody in Kakamega, Mombasa, or anywhere else can take a matter in Nairobi, and we do matters for all the regions. And specifically, we are glad that we are also able to do e-filing, so that we have embraced technology and we are able to dispense with so many matters every other day. We also do circuits for those people who are not able to. Every month we have a circuit. Like last week I was in Kakamega. The previous month there was a circuit for Mombasa, so that anybody who is not able to join the court virtually is able to join physically when we go for open court sessions. Perhaps the other issue would be the kind of disputes that we deal with are in regard to controlled tenancies. Controlled tenancies are tenancies which are not reduced into lighting, and they do not go beyond 5 years. And where they go beyond 5 years, if they are in writing, there is a termination clause for that particular contract. So that even if a tenancy goes for 10 years, and yet there is a termination clause, that still comes within our jurisdiction. We have no pecuniary jurisdiction like the ordinary courts, and therefore we can deal with matters involving even properties valued at very high value in terms of subject matter. Then there is also the issue of the issue of people coming to our court when we are not supposed to deal with the matters, especially those are especially for long-term leases. You'll find like somebody has a lease for 10 years. Because of the simplicity of the procedure, we want to come to the tribunal. And ordinarily, we don't entertain that. We dismiss those cases. You'll also find like even churches who are having problems with the landlords, and yet they are not shops, they are not hotels, they are not catering establishments, will come to us. We always actually refer them to the ordinary court. We strike out and tell them to go to the ordinary courts. We have also recently seen Airbnb being brought before us. And sometimes we wonder whether these are hotels, are they catering establishments? And we have been guided by some decisions of the superior courts. And more particularly, I was able to come across the case of Kenya Commercial Bank versus Jaribu Holdings Limited, 2007 into bracket electronic annual reports, where Justice Mohamed Wasame, as he then was, held that Airbnbs are not actually commercial premises. There are some premises which are excluded, like where government actually is actually a party. We do not take those particular disputes. Where the government or either county or national government is a party, we do not take those particular matters because they are not controlled within the proviso to Section 2. Our jurisdiction is to be found in Section 12 of that particular act. But where there is no landlord-tenant relationship between the parties who come before us, like where a tenant has been evicted, we do not entertain such matters. We say we have no jurisdiction. Perhaps the other issue is to do with our appeals. Our appeals are to the Environment and Land Court. So, but then if it is an appeal against a complaint under Section 12.4, you need to seek leave of the tribunal at the point of ruling or judgment, so that when you approach now the ELC, you are not told that the matter is incompetent. In regard to the issue of execution, we have no powers to execute our own decisions, and therefore we normally advise parties under Section 14, subsection 1, to file the decision in the subordinate court for purposes of execution as a judgment of that particular court. Of course, that is about to change when the tenants bill, the landlord and tenant bill, finally comes into force. I still understand it has been there since 2020 in Parliament. It is supposed to combine RRT and BPRT so that all matters to do with the landlord and tenants are brought under one roof. Unfortunately, it would appear like Parliament has not been in a hurry to deal with that particular bill. I think with those opening remarks, I guess I can end there. Thank you.
Thank you very much, Honorable Gakui. I think at this point I'll bring in Mukanzi if you're in the meeting.
Yeah, I'm present. Thank you, panelists, for your initial remarks. We will proceed with another set of questions, and to all panelists. And the question there has been a concern among some practitioners on the awareness around the various tribunals that we have. And of course, this directly affects access to justice. That if advocates and litigants wouldn't know how to go about these tribunals, then definitely there would be a gap in accessing justice. So the question would be, what steps has your respective tribunals taken to make the tribunals accessible by the members of the public, and most especially self-representing litigants? And as you answer that question, tie it with the concern on how accessible are your decisions. We have seen when decisions are given by the courts, most of those decisions get to be posted at the Kenya Law website. Is that the case with your tribunals? We would want to know where to possibly get your decisions for learning purposes and also for our own research. If we can start by Honorable Desma Nungo.
Okay, thank you, Mr. Mukanzi, for that very, very important question on concerns relating to concerns on awareness and aspects of access. And indeed, just to be very open, that's a very, very valid concern. And yes, there are mechanisms that the tribunal has put in place to enhance on its awareness. But even as we state so, we also must acknowledge that there's still a lot of work that we've got to do as a tribunal with the support of the different players to improve on that aspect of awareness, which has a direct bearing on access to justice. So very quickly, in terms of some of the mechanisms that have been put in place, some being continuous on awareness, is firstly, the judiciary and the Office of the Registrar of Tribunals has taken this initiative in terms of just bringing out or tribunals in various forums, whether it is in well-organized setups where the talk is about making tribunals known. Many have been done with the participation of lawyers and the public, whether it is in public events, for example, during the agricultural or whatever kinds of shows, or even during times like, for example, the devolution conferences, amongst other mechanisms. So there's a lot that the judiciary and the Office of the Registrar of Tribunals is doing in terms of improving that access. But the tribunal has also, especially in the past, partnered with the development partners and worked together with the Law Society in terms of making the tribunal known to lawyers, and this has led to different meetups between the tribunal and lawyers in different regions. So we've done in Kisumu, we've done in Mombasa, we've done in Nairobi. We hope to do much more, especially now that we are also facing the very, very critical time for the tribunal in terms of pre-EDR dispute resolution. So we have collaborated with various stakeholders in this, for example, IEBC and ORPP, where through the ORPP and also the PPLC, that is the Political Parties Liaison Committee, we find how to engage with our key players being the political parties in terms of just knowing about the tribunal is operating in the various forums that they organize for political parties, where the tribunal is brought out, introduced, the jurisdiction is made known. But we've also have had and will continue, especially with the build-up now, have more media engagement. We have had media engagements organized through the judiciary in Spice FM, where we've engaged on this, and more will be coming up, especially for the tribunal as we approach the pre-EDR. We've got knowledge products that are out on circulation in terms of the various reports for the tribunal from 2022, 2017, and just the different lessons that we learned and the recommendations we make from the different electioneering periods that the tribunal has experienced. So I say that there are things that are in place, there are more things that we are putting in place, but I also acknowledge that there's still a lot to be done, and it cannot be done with the tribunal alone, but with the support of various entities that we are key and are working together with. Now, in terms of access to justice, specifically, just how the tribunal is ensuring that even the people who are not represented, or just to make it easy for people to come before the tribunal, it stems from a lot of things. First of all, as we probably may all know by now, all the tribunal systems are now digitized, from the filing to how we handle matters, including even the virtual court processes. So it means that unlike in the past, for example, if some of you were present in 2017, where there were a lot of challenges at the PPDT, there was a lot of people who had to travel from different parts of the country to come all the way to Nairobi, some disabled, some in different states. But now with this virtual setup, and also with I forgot to mention, we've devolved, so we have 8 regions that are operational, both physically and virtually. But more so currently we are doing the virtual engagements, because we also get feedback from our users and also the advocates, and sometimes you get that there is preference largely for purposes of convenience for even just embracing that virtual. So that's there in terms of digitization, in terms of devolving our services. We have also made now moves like modes of approaching the tribunal as simple as it can get. For advocates, of course, drafting may not be an issue, but for the self-representing litigants, you will see that our regulations have forms that a litigant can easily use and just fill them up and come before the tribunal. Our procedures are fairly simple because even within advocates, people draft different things. There are people who come to the tribunal using petitions. There are those who come to the tribunal using plaints. There are those who come to the tribunal using originating motions. There are those who draft. I mean, everyone drafts their own things, but just to state that we are open so long as it is a complaint in the correct, containing the substantive requirements within the regulations, even if it is a form filled by hand, especially to favor those who may not be represented. We've got, I talked about the knowledge products. We've got FAQs all available in terms of just making it available for anyone who has, the frequently asked questions that need to be responded to. People need to know, where are we located? Where is the tribunal? What do we do? How long do we take to determine disputes? So there's a short form version of all these FAQs that we share in every forum that we go to, whether it is in an ASK show, whether it is in a political parties session, or whichever place it is. So we are really, really continuing to work more and better on this aspect of making the tribunal known to the members of the public. But of course, we do acknowledge that access to justice is very, very important because it therefore also marries in with the judiciary's stage plan. In terms of the decisions, I think there's also a question to do with that. Yes, our decisions are available to the public. If you go to Kenya law, you should be able to access the decisions from the tribunal. Over to you, Mr. Mukazi.
Thank you so much, Honorable Desmond Nungo, for your extensive explanation. So if we can proceed to Honorable Hilary Korir, the same question. How has your tribunal made it easy for the public to access justice, and if your decisions are available for litigants?
Thank you very much, Bwana Mukansi. For the Rent Restriction Tribunal, we have carried out sensitization workshops in various areas of this country. Recall we had one in Nakuru, Eldoret, Kisumu, and also Mombasa. We have also organized for stakeholder engagement, where we bring together chiefs, police, auctioneers, agents, landlords, and tenants for purposes of educating them on their rights and what needs to be done. Besides that, you will recall there was judiciary dialogue days. We also participated in all the stations that the tribunal is represented. Maybe I did not mention this earlier, that our tribunal is represented in 10 regions. All the former 8 provinces, at least one, except for the North Rift and the Coast Province, which has 2 because of the far-flung areas. So that makes it 10. So we have also in the past held Babbage meetings with the advocates to take on board their issues, and we will continue doing that in the near future. With respect to the reporting, our decisions are reported in the Kenya law, and you can easily avail them from there. Yes, I think that is much for that question for now.
Well understood, Mheshimiwa. Asante sana. Now we proceed to Honorable Gakuhi Chege. The same question, Mheshimiwa.
Oh, thank you so much, Kasi. I think talking after the able presentations by my colleagues, I think I would only build on that, because most of, especially what is the LRT has been doing, that is the rent restriction has been doing, is what we have also been doing. Whenever, remember, we are at the one secretariat, that is the registrar of tribunals. Whenever there is an activity that requires to be coordinated among all the tribunals, which have transited to the judiciary, we are also involved. We have actually participated in all those balances and sensitization sessions, like has been indicated by Honorable Hilary in Eldoret, Nakuru, and elsewhere. We have also had occasion to attend public balances, even in markets, to sensitize members of public, especially in Western, about the existence of the tribunals. Recently, there was an opening of shared services in Kisumu, which was attended by very many people, including the Honorable Chief Justice as the chief guest, and I think the governor of Kisumu was there, and it was well attended, and that was also a selling point for the tribunals. We have actually participated in media interviews, in electronic media, and our members have been present to field questions and answers in such sessions from members of the public, In regard to access to our decisions are reported in Kenya law report. Although I note that there is a challenge in regard to availability of decisions once they have been uploaded on the CTS. I understand that there is a small problem because the setup of the portal does not allow, unlike ordinary courts, that you just access a decision without paying the requisite court fees. I think it is something that we are working on. We have raised it with the judiciary ICT because it is also not good to read a decision. It is uploaded, but is not accessible to members of the public. It is something that perhaps that should be addressed as fast as possible. But we also have WhatsApp groups where the lawyers who have any issues to raise with us are able to raise, and we are able to answer them. For every region, we have a WhatsApp group, which is actually accessible to all members in that particular region. And I think, as I had said earlier, we have regional offices in all the former provincial headquarters, and we have staff. What I have seen is, like in Kakamega and some of the other regions, we are able to also set up the virtual platform for those people who are not able to use, who do not have access to smartphones. They are able to go to our regional offices and they join using laptops or other gadgets that are provided for use in our regional offices, so that nobody is shut out from accessing justice. I think with those, then there is also the issue about the forms. Like has been said by Honorable Desma, our forms are a bit simple, but sometimes can be a bit complicated. They are prescribed forms. Unfortunately, what I have seen is like many people do not understand, and there has been very strict interpretation about what is prescribed. So that if you feel the landlord's notice to terminate a tenancy, and then you are not aware about the interpretations by different courts on what it means by prescribed form, you end up finding, like when you come to us, the form is declared invalid. Perhaps there is some, we can do something better. And perhaps I think I would call upon lawyers to seek a better interpretation of the term prescribed form under section 4 subsection 2 of Cap 301, because the decisions that we have seen coming from the superior courts is that the act is very strict in terms of prescribed form, and despite trying to apply Article 159 1D, 2D, sometimes courts have overruled that the prescribed form must be the form which is in the schedule to the act. So that at the end of the day, you find like sometimes somebody might bring an application which contains virtually everything that would be in a reference, but then that application is considered incompetent on the basis that you have not filed a reference, that is Form C or Form B, or you have not challenged a notice under Section 6.1 using the correct form. So that, and I think this is a problem that has been occasioned by the interpretation that has been given by the superior courts. Perhaps it is the high time lawyers who are able to assist us, those who litigate in this particular court, to assist us to have a different interpretation, perhaps by the highest court, like the Court of Appeal, because at the level of the superior courts, the interpretation is just too strict, and sometimes it may occasion a miscarriage of justice. That's all.
Thank you, Honorable Gakuhi Chege. And so we proceed to the next set of questions, and in the same order of how you've done in the previous question, we will go. The question is, where do appeals from the decisions of your tribunals go? Members want to know if they are dissatisfied with the decisions of your tribunal for whatever reason, where they would possibly appeal at. And that will be answered together with the question, what are the common grounds upon which your decisions are challenged on appeal or through judicial review? So, Honorable Desma, you go first.
So, on the question relating to appeals, now appeals from decisions of the PPDT go to the High Court. Now, the law does not specify which particular division of the High Court that appeals should be filed. So the practice currently is that they go to the civil. But I am aware that there are discussions that are ongoing, especially at the level of the Judiciary Committee of Elections, to find common forum where all appeals that would be arising from the tribunal would go, so that they also keep themselves aligned with the ongoing electoral timelines. But currently, appeals go to the High Court. Common grounds of appeal against tribunal decisions. Many a times grounds relating to jurisdiction play along at the level of the High Court, whether the tribunal had jurisdiction to sit and determine a matter. And of course, it's also related to the questions that I'd stated earlier to do with the application of the IDRM for specific kinds of disputes. And of course, the other common grounds of appeal relate to an error of law, where perhaps the tribunal members would have wrongly applied the law, misapplied the law, or wrongly even interpreted the law. Just like in any appeal, those are grounds that are likely to play for appeal against decisions of the tribunal. The other grounds relate to, for example, the feeling by parties sometimes that the tribunal did not consider certain points of evidence or material that was placed before it, or that the tribunal considered extraneous issues that were not placed before it. So they are varied and as open as any mistake can come out in terms of a mistake in law, a mistake on interpretation of also the evidence or the facts. So basically, that's how it is in terms of the common grounds of appeal. There are also aspects that come on appeal in terms of maybe the perception or feeling that there could be bias in determinations by the tribunal. So those also sometimes constitute grounds pursuant to which councils or even parties move to the High Court to file their appeals. So the other thing that is the JC is also trying to address is, as you are well aware, for matters before the tribunal, the days that it takes to hear and determine them is 90 days, meaning 3 months. So if you have any matter at the tribunal, you count 3 months from that particular date. So obviously, we cannot render any decision outside that particular period. But in terms of now the appeal process, again, you will note that there are no timelines within that. So again, there's that area that is under discussion for purposes of just continuing on with the spirit of expeditious disposal of political party disputes, which call for quick determination, even at the various levels of appeal within the structures that are available in law. So I'll leave it there for now in terms of the question on appeals. Thank you.
Thank you so much, Honorable Desma. We proceed to Honorable Korir.
Honorable Korir, kindly unmute.
Sorry, and thank you, Mr. Mukansi. Appeals from the Rent Restriction Tribunal goes to the Environment and Land Court. My colleague there, Honorable Desma, has enumerated the grounds very well. They cut across. Most of the grounds here border on jurisdiction, factual issues with respect to rent arrears or non-disclosure of material facts. Others include an error on the of law and perceptions of bias. Those are some of the grounds that most of the matters go on appeal. And the other challenge we are having at the rent tribunal, is, restriction tribunal, is the existence of conflicting decisions by the superior courts, especially on the question of jurisdiction, so that an advocate will be representing a landlord would have an authority different. There are, of course, and those that are representing tenants would have authorities that would support their case with respect to the issue of jurisdiction. I earlier saw a question on the chat. I don't know whether maybe I can take it at this point in time.
You can take it, Mheshimiwa.
Very well. Somebody was asking whether it is about time the law was reviewed. Indeed, the review process has been on since the year 2020 or even earlier, as has been alluded to by my colleague. The landlord and tenant bill has been pending in Parliament. That bill, as you were told earlier on, seeks to bring together the rent tribunal and the rent restriction tribunal, as well as the landlord tenants tribunal, and to also provide for jurisdiction of the tribunal. It also seeks to empower the tribunal to enforce its own orders, because as you know, currently, tribunals do not enforce their own orders. You have to file a miscellaneous application again before the magistrates' courts once you've got an order. It will also seek to empower the tribunal to award damages. In fact, that is where we get most of the advocates filing claims for erroneous, of course, claims for damages at the tribunal, quite unaware, of course, that the tribunal has no power under Cap 296 to award damages. So we are hoping that with the enactment of that bill, the landlord and tenant bill, these issues will be addressed and we'll be able to move forward and render justice appropriately to the people concerned. Thank you. I think that should be.
Thank you, Honorable Korir. And lastly, Honorable Gakuhi, if you can take the same question.
Thank you so much. In regard to appeals from the Business Premises Rent Tribunal, like I had said earlier, our appeals are normally appealable to the ELC, and the ELC is supposed to be the ELC of the region from which the particular matter comes from. So that if it is a matter for Kisumu, you appeal in ELC Kisumu. If it is Kisii, you appeal in ELC Kisii. And likewise, for Nairobi, you appeal to the ELC Nairobi. So that at the end of the day, we have all the ELCs within the country having jurisdiction over matters that come from the particular region. The unfortunate bit about it, the appeals are normally filed within 30 days, just like in the Civil Procedure Act. But then on the flip side, like I had said earlier, you cannot appeal, and I have seen decisions to the effect that an appeal against a complaint, these are normal complaints under Section 12.4. are incompetent as long as you do not have leave of the tribunal. So it is always good as an advocate intending to appeal to always ask for leave before you file the appeal, because you might go before a judge who is a bit strict and find that like your appeal is incompetent. Trying to come back to the tribunal, time has already elapsed within which perhaps you could appeal. The other issue perhaps is to do with the common grounds of appeal. Just like my colleagues have said, they cut across issues of jurisdiction that the tribunal entertained a matter perhaps that they should not have entertained, that issues of merit, that the tribunal did not determine the matter on merit, just like an ordinary court, errors of law, and sometimes even procedure. Like I had said earlier, our procedure is that for applications and simple complaints, like on disconnection of water, injunctions, and all that, we normally deal with them on submissions. And we mostly do not allow parties to highlight the submissions, so that some people feel like where you do not do a normal hearing, it is like you have not given that particular party a fair hearing. And sometimes you find a party going on appeal based on such reasons. On the flip side again is that sometimes appeals go to the ELC and they take too long, so that at the end of the day, you lose the expeditious, the speedy nature of resolution of disputes. Because once they join the mainstream ELC appeal and actually become part of the matters that are pending before that court, no priority is actually given. And therefore, whenever an appeal is filed, perhaps you find like it is taking like 2-3 years before it is resolved. And at that time, if it is a tenant who has not been paying rent, sometimes you find like he stays in premises for like 3 years when he has already been granted a stay. You cannot go back to the tribunal. And then you find like by the time the appeal is determined, the tenant vacates the premises, and that actually becomes a miscarriage of justice. So that at the end of the day, we perhaps have recommended that the best way is to have a special way of treatment of appeals coming from the tribunal, so that we retain the simplicity, the speciality, the speedy nature, and the expeditious nature of resolution of disputes. I think with that, I think I am done. Thank you.
Thank you so much to our panelists for that round of questions. I shall hand over back to Effie for a round of specific questions to individual panelists. Thank you.
Thank you very much, Mukanzi. We'll take more personalized questions directed to the speakers personally, and then we'll have a session of Q&A. So feel free to put your questions on the chat. And if it is a very burning question, you can also raise your hand and we'll give you a chance to ask the question. So the first question goes to Honorable Korir. Honorable Korir, the question is the limit of tenants paying rent at 2,500 and below. Is it time that we rethought that amount? Because are there really a lot of Kenyans paying 2,500 and below? And if there are, do they know about the tribunal?
Thank you very much, Madam Sheila. Indeed, that's the question that I had seen on the chat. And I have stated that there is a law under consideration in Parliament since the year 2021. It's called Landlord and Tenant Bill, which is seeking to increase jurisdiction. We had proposed that it be increased to about 50,000 because we were basing it on the on the understanding that the 2,500, when it was set, was in the year 1981. And the kind of places that that rent was available then was the now Buruburu, the Nairobi West, and the like. So that if you consider the amount of rent currently going in those areas, it would be in that region of about 50,000. There are also, like I've said, conflicting decisions by the superior courts, whereby some decisions say, of course, standard rent is as defined under Cap 296, which is actually limited to 1981. So if you can demonstrate that standard rent in 1981 was that much, if you can't, then you will have to apply for assessment. And the tribunal will have to assess and then determine now whether the standard rent is beyond or below. So that's a major challenge that we are facing, and we are hoping that the enactment of this bill will address that problem to a large extent. Thank you.
Thank you. Thank you very much, Honorable Korir. And up to Honorable Desma. 2027 is almost here with us. So what is the tribunal's position on disputes that involve political party coalitions, especially when there are no clear dispute resolution mechanism that exists between the coalition agreement? But aren't you to tie that with are there instances where you have encountered a clash of jurisdiction between the tribunal, IBC, the tribunals, the political parties, the dispute tribunals, and the High Court?
That's it. All right. Thank you, Effie, for that question. Indeed, 2027 is around the corner, and I would state that PPDT is prepared, and it's also still preparing in terms of handling of pre-EDR disputes that we expect to be on the rise. We normally call it a spike period. So just to mention that preparation started way long ago after the last electoral cycle, because you all appreciate that each electoral cycle usually has its own unique dynamics, and in every electoral cycle there are usually lessons that are learned. And I'll tie this together with now the specific question on the coalitions and clash of jurisdictions. So yes, there are preparations that are ongoing, both administrative and also in terms of legal. Given an opportunity, I don't know whether this is where I could highlight just a few of the plans in place. Is that okay, Effie? Before I get to now the specific question on coalitions and the clash of jurisdictions. Yeah. So just to mention that, for example, with respect to pre-EDR of 2027, we've picked from it. And for your information, we've got a digest, a case digest, which also speaks to our journey towards pre-EDR in 2027, the challenges that the PPDT faced, and the areas that call for attention, especially as we move towards the next pre-EDR session. So what normally happens is that evaluation meetings are done after the electioneering period, debriefs, and then we come up with this product. Now, in terms of the reforms, and just to mention that we've also got documentation in place that speak to the preparedness of PPDT, captured all in whether it is the PMMU that PPDT has signed with the JSC, whether it is in the PPDT Service Delivery Charter, whether it is in the PPDT Work Plan, whether it is in the operational manual, or the kinds of engagements with stakeholders and also with the JCE. So all these are documented. Very, very briefly, in terms of, they touch on both administrative preparations and also legal in terms of reforms and what have you. So in terms of administrative preparedness, of course, what we expect to be seeing soon is the full operationalization of the devolved regions. We still have our devolved regions in place. Even when you go to the system, the filing portal, you'll see the regions are still in place. Parties have been filing disputes dependent on the regions. So what we'll be working towards is in terms of the physical presence. Of course, we could not sustain that physical presence throughout because the reality is that backload, the workload reduces after elections. So much that is present, we have handled it even as we do the regional, but we try to also maximize on technology to reduce on costs. So we are looking towards that full operationalization of the devolved regions. Of course, with the increase of spike, we'll need a lot of staff redeployment. So plans are already underway in terms of both the members and the staff. And when we talk about staff redeployment, it would be a matter of not necessarily getting in new staff from outside, but the judiciary, they usually have a way of redeploying staff to serve where there are extra pressures to be attended to. Membership recruitment, in the coming period, there will be the recruitment of ad hoc members. That is the 18 members that I'd referred to. The opportunity for 9 lawyers from those 18 members, because from the 18 members, there are 9 who must be lawyers, and then the 9 are non-lawyers. So we are doing a lot of training, and we will also be doing a lot of training and capacity building of both members of staff with the support of the Judiciary Academy, and with the support of even our development partners. We're looking into improvements of the CTS. We've listened to advocates through our bar bench engagements in terms of the challenges they experience, and whatever attention needs to be done to it, we are looking into it. The major issue, of course, obviously, is funding. So we're also addressing how to attend to those funding gaps through our development partners. Now, in terms of legal reforms, there are talks on reforms, not just from the PPDT end, but also from the, which is under the JCE, of course, but also from the Office of the Registrar of Political Parties and also from the IEBC on various laws, specifically with respect to elections or nominations. There's the Political Parties Act, and there's also the Elections Act. Just to point out, for example, a few of the areas that are under discussion currently is there's a question as to whether there are actually major reform areas that are being handled, but I'll just highlight a few that really concern the political parties' dispute resolution. There are engagements towards the appeal structures that are available currently from PPDT to the High Court. And then the question that is being asked is where should it stop? For purposes of enabling also the other players in the electoral cycle to perform their respective roles with a view to delivering timely elections. So those are discussions that are there. I'd mentioned about an appellate chamber or to deal with this resolution of appeals from the PPDT at the appellate level, and also some recommendations for even within the tribunal itself, just to expand it with a structure that comes to the appellate level. So those are things that are under discussion. One major thing which will come out and ties also to the issue of clashes in jurisdiction is the clarity on jurisdictional competence and boundaries between the PPDT and IEBC. Both the PPDT and IEBC have the jurisdiction to handle nomination disputes. So usually there's that a clash that comes up where sometimes parties forum shop. There are instances where people file at the tribunal. Some of them file related or the same before the IEBC Dispute Resolution Committee. So in the past, what we have done, for instance, is that between PPDT and IEBC, we've worked on some memorandum of understanding where we have tried to list out the kinds of engagements or disputes that should be taken to IEBC and the kinds of disputes that should be taken to the PPDT. We are grateful that it's been working with the support especially of the legal fraternities who very ably represent their clients and cooperate in terms of filings. But even as we say so, we also acknowledge that well, it calls for reforms to be conducted on that area so that there's that clarity. There's also the aspect of political party funding. I didn't mention that some of those are also disputes that come up. There is the section 26, which talks about the funding being distributed on the basis of votes secured. When you have your own time, you can look at section 25 and the issue of distribution of political party funding. But what courts have noted as emanating from disputes that start way down from the tribunal or at party levels all the way to the courts is that that particular provision is not very clear, especially in places where elections would be conducted and the candidates are declared, but there are no votes. They are not elected with votes as such because there was no opponent. There is also calls for reforms on how this question of ad hoc members should be handled in terms of appointments to deal with the institutional memories. On Elections Act, there are many, I think for matters politics and elections, it would require more time maybe, and we'll be looking into engaging where we have more time, because I'm really quickly brushing through these things, but there are many calls for changes in the Elections Act. You'll be hearing discussions to do with even changes in terms of the period within which the Supreme Court should be hearing on determining presidential election petitions. Many changes being proposed in the Elections Act in terms of how courts handle issues of scrutiny, harmonization of the positions of, for example, that deal with automatic stay, because you note that if you want to appeal against the High Court determination to the Court of Appeal in an election, usually there's that automatic stay. But when you're coming from the Magistrates Court to the High Court, there's no automatic stay. So a lot of time is spent with interim or interlocutory applications that come up. So in due course, we'll be able to highlight, because they're still at the stage of participation. The only challenge we have with this country is that in as much as these things are present and people participate, but we've got also this challenge of having this last minute amendments coming up. We experienced that in 2022, where the ad hoc issue was introduced very late in the day, and there had to be a rush for recruitment of people to support the PPDT in terms of resolution of disputes. So there's lots going on. The PPDT is very busy, well alive to what's coming up and the dynamics and the call of duty that comes with that. Now, other than the jurisdictional clashes between the IEBC and PPDT, which I've explained, and which are also subjects of discussion in terms of reforms, yes, there are also clashes with PPDT and I wouldn't call it a clash between PPDT and High Court per se, but just the way my colleagues mentioned that the High Court also sometimes have given contradictory determinations on matters that affect PPDT. For example, a live example is that initially on the question of IDRM, there were different schools of thought where the High Court felt like it has to be exhaustively exhausted. And this was arising from appeals that went to the High Court from the PPDT, where the PPDT, looking at the realities of political parties and the fact that some of them actually calculatively make their IDRMs not accessible and therefore frustrate members, should then allow people to, where there are those exceptions, move to the PPDT. So yes, there were those contradictory positions. Thankfully, the 2022 amendments tried to rectify that. You will note that they use the word attempt. I will invite you to consider the numerous decisions in terms of how the tribunal has considered the question of attempt, so that it's not just a matter of attempt, because we've had instances where somebody writes a letter today and tomorrow they're already before the tribunal and they're claiming that that's an attempt. So there's a lot of jurisprudence on that. Councils especially who come before the tribunal, as I said, those are issues that come, 90% jurisdictional issues that come before us. So even as you read the word, first, do not use the law that was there before 2017, before 2022, which says that a dispute has to be heard and determined before the IDRM. The wording right now is an attempt at IDRM. But then again, look at how the tribunal has interpreted that question of attempt. Once you have that understanding, it saves time, it avoids matters being struck out, and you're also able to serve your respective clients better in whilst you appear before the tribunal. There has been issues of constitutional issues, of course, with the clashes. The High Court has said that to some extent we must apply the Constitution. The same High Court has said that we cannot render some determinations. So those are clashes that are there. On questions of contempt, the High Court has said that we cannot punish for contempt. The tribunal has made efforts towards, and you will see in section, I think it's 41, you will see the amendments that were introduced which gave the tribunal powers to punish for contempt, similar to what the High Court has. So the PPDT is one of those tribunals that is strongly clothed in terms of enforcement of its decisions and the power to punish for contempt. Just to mention also, clashes, the real ones that happen with councils, parties file constitutional petitions before the High Court on issues to do with political party affairs, clothing them, of course, as constitutional issues. The High Court has on numerous occasions and on the strength of the doctrine of constitutional avoidance, returned those matters or struck out matters stating that the tribunal should handle those disputes. But then again, you hear instances where also the High Court has attended to some of those matters. So these are some of the areas where you would see a bit of these clashes coming up. But otherwise, I think with the continuous engagement that come with both the parties and also with all the judicial officers across the board, I believe that we would be able to work better as time goes along. It's a continuous learning process, and we are still making it or working towards making everything better for the betterment of our delivery. Thank you.
Thank you very much for that very elaborate feedback, Honorable Mungo. The last question from our end, and then we'll go to the questions on the chat, and we'll give members a chance to also ask questions, is to Honorable Gakui. Honorable Gakui, the Landlord and Tenant Act provides for controlled tenancies, but we find that many times landlords attempt to convert them into long-term leases so that they're not oversighted by the tribunal. So how does the tribunal deal with such attempts to oust its jurisdiction?
Thank you very much, Evie, for that question. As you all know, as lawyers, the work of the courts, just like the tribunals, is interpret contracts made by parties and not to make contracts for them. I think you are aware of the National Bank case versus Sam Korit, which stated as much that the work of the court is to interpret the contracts made by the parties so that there is no way the tribunal will actually take up a matter where it has no jurisdiction. Because at the end of the day, if parties have entered into an agreement for more than 5 years, and does not have a termination clause, certainly that is not a matter within the jurisdiction of the tribunal. And therefore, we normally avoid taking up that matter because it would be a narrative, making a decision on such a matter. So it behoves on the parties or the lawyers who would want to resolve any disputes arising from written agreements to ensure that the jurisdiction of the tribunal is preserved. But most often, of course, it is the lawyers also who will say, we don't want any clause that is geared towards ensuring that the matter comes before the tribunal. Especially sometimes back, you will remember there was only one member of this tribunal, so that parties were even avoiding a situation where they would fall into the trap of coming before the tribunal, because once an injunction is given, a matter will not be completed maybe until after 3 years, 4 years, sometimes even 5 years. Currently, because we are 10, and as I have said, we are 8 courts, matters are moving fast. We have, of course, memorandum and understanding on performance understanding that our matters are completed within six months. And for purposes of applications, we normally complete them within a period of about 3 months, so that there is no danger. Otherwise, for purposes of long-term leases, there is no way we can actually guide the parties. I think lawyers are in a better position.
Thank you
Over
very
to
much,
you.
Honorable Gakui. Allow me to bring in my co-moderator to take the next set of questions. Titus Mukanzi.
Thank you so much, Effie. So far, so good. We are faring on well. I have a question from my colleague, Ms. Temugo Kibeta. The question is, can the Rent Restriction Tribunal entertain eviction proceedings where the house rent is like 90,000, just a landlord asking the tenant out? Issues of rent are not in question. Commissioner, if you can take that.
Thank you very much, Mukansi, for that question. As I said earlier on, the ceiling is spec at 2,500 standard rent, but standard rent is defined under the Act to be the rent that was applicable as at 1/1/81, 1st January 1981. So if you can demonstrate that the subject premises was either in existence as at 1st January 1981 or had not been constructed, was not in if it was not in existence, then it will have to be subjected to evaluation of assessment of standard rent to determine the standard rent. So it is clear that the standard rent should be 2.5, and it is pegged at 1st January 1981. Thank you. I hope I've answered your question.
I believe you have, Mheshimiwa. We have another question from Mr. Mushangi Patrick, and the question is to the Business Premise Rent Tribunal. How does the tribunal decide jurisdiction when premises are used both as a residence and for business? For example, a home-based clinic or home office for virtual business. And what factors, and what factors determine whether CAP 301 protections apply?
Oh, thank you very much, Titus, for that question. I think basically, again, we go back to the agreement between the parties. If, for example, the parties have contracted for, in writing, for example, for the tenant to run a shop or a hospital or whatever other business like a restaurant, and the tenant decides to also use that premises as residential, certainly the agreement would prevail that the premises are for commercial purposes. And where the tenancy is for less than 5 years, certainly that would come within the jurisdiction of the tribunal. If it is for more than 5 years, certainly it now falls outside the jurisdiction of the tribunal, and it has to go to the, if a dispute arises, has to go to the ordinary courts. Otherwise, it is the original user of the premises that would actually define whether it is within the jurisdiction of the tribunal or not. Secondly, perhaps I think the tribunal's jurisdiction is set out under section 12, subsection 1 of the Act, so that a lawyer looking at the matter will look at whether, one, the tenancy is controlled under section 2, and number 2, whether the issue falls within section 12, subsection 1, so that it becomes very easy because the tribunal's jurisdiction is well set out in the Act. Thank you.
Asante sana. We have another question from Mr. Osborne Lijodi, and I will ask Honorable Desma Nungo to take this. And the question is the issue of costs. Does your tribunal tax them? Are they covered by the remuneration order?
Thank you, Minister Mukanzi. Yes, the tribunal has discretion to make powers relating to costs, and yes, taxation is done at the tribunal. There is a designated deputy registrar who undertakes the taxation of costs for all applications that are filed before it. And yes, they are guided by the remuneration order. There's the section that deals with tribunals, and that's what guides the taxation process before the taxing masters. Thank you.
Asante sana. Is that the situation with your tribunals, Honorable Korir and Honorable Cheke?
Yes, thank you, Bwana Mugansi again. Indeed, that is the situation. There is Schedule 9 of the Remuneration Order provides for matters before both the RRT and the Landlord and Tenant Tribunal. And they can be taxed at the request of an advocate or a litigant. But of course, again, the tribunal has discretion to award costs. Thank you.
Thank you so much. Honorable Gakuhi?
Yes, the same situation actually obtains in the Business Premises Rent Tribunal. We either award costs at the point of ruling or judgment, or the costs can be assessed or taxed by our deputy registrar. Fortunately, these days we have deputy registrars and assistant deputy registrars who do the taxation, just like in the High Court. I think the tribunals have been elevated to a different level altogether. In fact, when we give our orders, the orders are usually signed by either the deputy registrar or the assistant deputy registrars. So that is the situation.
We move to the next segment where we shall take questions directly from members, and the order shall be as according to...
Perhaps, Titus, before you get into that, there was a question that I have seen on the chat about the eviction process regarding the Business Premises Rent Tribunal, because I have seen decisions, even from the Court of Appeal, saying that once a notice to terminate tenancy has taken effect, then the tribunal lacks jurisdiction. But when I looked at that particular decision, I think it is called the Nadral decision of the Court of Appeal, it did not appear to consider Section 12, subsection 1E of the Act. Section 12(1)(e) empowers the tribunal to make orders for recovery of possession and for payment of arrears of rent and the mini profits, which orders may be applicable to any person, whether or not he is a tenant being in occupation of the premises comprised in the tenancy. That particular decisions and the other decisions that have dealt with the question of jurisdiction post the notice taking effect under Section 10 did not consider Section 12(1)(e), which expressly gives the tribunal power. So you can bring a reference by way of a complaint under Section 12(4) that I served notice upon a tenant and the tenant failed to vacate. And being a person in occupation of a premises, certainly you would be entitled to apply for an order of vacant possession. And we have been actually granting such orders against such a person who has become a trespasser, because whether or not a tenant or in the premises comprising a controlled tenancy. I think I leave it at that.
Thank you so much, Honorable Gakuhi. I will also invite the panelists to scroll through the messages and check if we have any of the questions we haven't touched on and they would want to respond as we take the next set of questions directly from members. We shall now invite members to lift their hands through that function here so that we take your questions directly. Effie, you lead us in that.
I think as we take the questions from members, there's one question to the rent restriction tribunal. That's to Honorable Korir. My question is from Velna. My question is, in the event that a tenant files a certificate of urgency before the rent tribunal to avoid eviction from residential premises where the rent is above 2,500 and the tribunal grants interim orders in their favor, what remedies are available to the landlord? And I think this has happened to me. I have gotten orders despite the rent being above 2,500. So perhaps just a little clarification. What happens in that case?
Of course, like I said earlier on, standard rent is defined and is relative to 1st January 1981. That 2.5 that you see under the Act. And it has been defined under the Act. So it behoves of you to demonstrate that that amount has either been assessed by the tribunal and found to be the correct amount, or that the premises was in existence and that was the rent by then. So this is where I was saying we have contradictory decisions by the superior courts, and this is where we're having a challenge and hoping that the bill will be enacted soon so that the matter is addressed once and for all. Thank you.
Just one final one, Honorable Corinne, before we take the questions. And members, feel free to lift up your hand. Then we'll take the set of questions in the order of the hands lifted. How does the tribunal handle cases that involve vulnerable tenants? Is there like a special consideration given to people with disabilities or refugees or the elderly, or the law applies to everybody equally?
There are no special provisions under the Act, but with respect to people living with disabilities, for instance, the deaf, of course, we seek the services of sign language interpreters. With respect to the elderly, we exercise our discretion and give them first priority. As for refugees, I'm not aware of any case that we have received here, but generally we have discretion in the interest of justice. We can exercise our discretion, but there are no special provisions under the Act.
Very well. At this point in time, a colleague is saying, Patrick Lavins, I don't know if you're ready. I've seen your hand. Then I'll take Amos Mutuku as a second person in that order.
Hi, good afternoon. Can you hear me?
Yes. Please add your volume just a bit, but we can hear you.
Is my audibility now vibrant? Can you hear me?
Yes, we can hear you.
Awesome. Thank you. So good afternoon to my learned friends and Honorable Korir, good to see you. I know you may not recall, but back then when I was still working in the Kenya Private Sector Alliance, we were involved in the validation exercise of the rent restriction registry manual and service charter. That was, I think, 2 to 3 years ago. And we interacted with you then. So my first question will be premised on my first question would be premised on how often does a review occur the service charters of these tribunals and the one that you are currently heading? And then the second question will be focused on how have you perhaps been involved to midwife the challenges that have bedeviled tribunals, including the inadequate infrastructure and, of course, that has impacted the operations of tribunals? And how have you managed to address these challenges with either the Office of the Chief Justice and in collaboration with Parliament during the budget making process, just to address these constraints that have impeded adequate, access to justice and dispensation of matters before you. So that will be all for me, and thank you for your audience.
Thank you very much, Patrick. With respect to the registry manual, I think this matter, the Office of the Registrar Tribunals has taken it up seriously. And now we have a cross-cutting manual for all the tribunals and charter, which is supposed to be reviewable. If my memory serves me right, I think should be every 5 years. And I recall that I think it was in about 2023 is when the one that is currently in force was reviewed. With respect to the second question on challenges associated with inadequate infrastructure, that is a question that is tied with the budgetary allocations. And budgetary allocations are from the Chief Registrar of the Judiciary. You are aware that there has been what we call austerity measures in the recent past, and the judiciary budget has been seriously slashed. So this has affected the tribunals, both in terms of purchase of necessary equipment, infrastructure, as well as also recruitment of staff. We are faced with those challenges, and we can only pray and hope that something will be done to address that concern, so that the tribunals can be properly resourced to enable them deliver on their mandate properly. I think that's all I can say with respect to that.
Thank you, Honorable Korir. I think I hope you have well answered, Lavins.
I am. Thank you. Thank you, Honorable Correll and my council member. Thanks.
Thank you. Thank you too.
Thank you. We'll now let's hear from Amos.
Thank you, Effie, and thank you, Mukanzi, for taking us through this session. Thank you also to all the speakers. It's been an illuminating session. My name is Amos Mutuku, advocate practicing in Mombasa. And my question goes to all our panelists. I think all of them have mentioned that tribunals are not, unlike courts, they are not ordinarily bound by the strict rules of evidence, the civil procedure, ordinarily what we do in the magistrates' courts and the high court and so forth. The discussion among practitioners is that especially for litigants that are appearing in person before the tribunal, there is I don't know whether to say a tendency, but it's like, the tribunal or the presiding officers tend to guide the litigants too much, almost to a point of it's like they are assisting them in conducting their case. I just want to find out from the three panelists that we have had today, how do they strike a balance? I mean, where do you draw the line such that a litigant that is self-representing is not stuck. They might not know the rules. They might not even know what to file. Some may just write a letter to you guys. How do you draw the line? So that the lawyer, obviously the defendant, a lot of times will have a lawyer, so that they do not feel like the tribunal is assisting the litigant conduct his or her case. Thank you.
I think that's directed to either Honorable Korir or Honorable Gakui, right? Or both?
Yes, I would have loved for you to go through all three panelists, but I presume for the PPDT, a lot of the people that go there, they're politicians, they can pay lawyers. Highly unlikely that you'll have litigants acting in person. But for both of them, I'll say.
Very well. I think
Okay, maybe I can go first. Okay, it is true that majority of the clientele that we get at the tribunal are kind of, so to speak, vulnerable or underprivileged, and may require to be guided not only on how to file, even during the proceedings, because they may not understand. But for us, we work closely with the Kituo cha Sheria. We refer them there, and they are normally assisted pro bono, so for drafting, that is. But of course, in the course of the court session, the presiding officer has an obligation, not necessarily under obligation, but can guide by way of explaining and showing the litigant what needs to be done. Of course, not to the detriment of the other side, the advocate who is on the other side. So I think there we have to exercise our mandate and discretion in the interest of justice. After all, our 2010 Constitution tells us that we should not dwell so much on technicalities of procedure, but rather seek to do substantive justice, which is also provided for under the overriding objectives of the civil procedure. Thank you.
Thank you so much. If we can call on Wakili Dalmas to proceed with his question.
Before Dalmas, Honorable Gakui was waiting to answer that question as well, then we can take the next set. Honorable Gakui. I don't know. Honorable Korir, can you hear me?
Yes, I can hear you loud and clear.
Okay,
he's having challenges probably.
I had seen him ready to take on it. Okay, very well. Back to you, Titus.
Thank you. I had called on a participant by the name Dalmas to shoot his question.
Good evening, panelists and also my colleagues. I think whatever I wanted really to know is kind of a follow-up, because I had a question that Mr. Amos asked, but I wanted maybe a rejoinder to that question, because not only the litigants who are faced with this challenge of document, we see that there are junior advocates who really don't know which documents to be filed. So in case of a litigant, it's understandable. What if a an advocate come or approach the tribunal with a plaint and instead of maybe some simple documents? What are the way forward?
Okay, thank you, Dalmas. If I may again go first with your kind permission, Elfie.
Yes, please.
Well, I think for the learned friends, of course, it is expected that they went to school and understand or know what needs to be done. But in our case, they will be guided in the registry. The matter will not be admitted. If there is something missing, you will be guided that you go and rectify the situation to avoid a situation where the matter will come for hearing and then it will be struck off. So we prefer that the problem be sorted out at the registry so that you can rectify it at that point.
Thank you, Honorable Gakui. I think that can also apply. I don't know whether Honorable Korir, I don't know whether Gakui
Yes,
can.
I think Honorable Korir is answering the questions quite well. He's doing my job and I am happy because exactly that is what we have been doing. Whenever somebody does not file the correct form, we normally tell our registry staff to ensure that they call the lawyer and tell them to guide them on, including lawyers, on the correct forms to be filed, so that when matters come before us, they are not really dismissed on technicality. And like he has said, I think the Constitution, Article 159 2D, behooves us to do substantive justice rather than technical justice.
Very well. Let's take another hand. There's Mureti Cosmos.
Hello, good afternoon.
Good afternoon, Cosmos. We can hear you.
Yeah, my question is, why do the tribunal fail to approve the judgment and or ruling until we make payment for them or we follow up with the court assistant? Why can't they just approve them once they are delivered?
Perhaps that is an issue that I had earlier addressed, Ivy, and I think it is the setup of the system so that unlike the ordinary courts where you immediately a judgment is delivered, it is uploaded and it is accessible to the parties. The ICT department, for whatever reason I have never understood, has set up the portal in a way that the judgment does not become accessible until payment is made. For whatever reason, this is an issue that is being addressed at a different level. We have raised it because we think that it is not fair. Sometimes you will find like a judgment has been delivered and it is not available to the parties, even for purposes of appeal or for execution purposes, because it has not been uploaded. I think it is a matter that is being dealt with. It has been actually raised by litigants, by advocates, and I think continue raising it until the matter is addressed. Otherwise, we also feel that it is a matter that should actually be dealt with, so that even if it means charging an extra fee to ensure that once the judgment is made, you'll be able to get that particular judgment or ruling. It should not be based on making an application for it or even paying for it. Otherwise, it is about the system.
Thank you so much, Honorable Gakuhi. Any other questions? Anyone else who wants to ask a question or seek a clarification? And as we wait for that question, it is important to note that MLS member Mr. Amos Ndunda sits at the Water Tribunal. Karibu sana, Bwana Amos.
Mukanzi, I think as we wait on the members, I have a request from a few of our colleagues saying if the tribunal and the speakers can share on the chat email addresses to the tribunal and or phone numbers that our members, in case they are stuck, they can reach the tribunal on. It would assist us to at least have an easier way in handling some of these issues. I see Cosmas has raised his hand again. I don't know whether it's a number of questions again.
I have raised my hand again, Shada, because my concern is sometimes this tribunal does not admit you immediately when you try logging in. You can spend even several hours without admission. Why can't they make it automatic? Because you spend a lot of time calling the court assistant to admit you. And sometimes they ignore you actually.
Maybe if I can attempt to answer, I guess that is a matter for IT department, because we are all lay persons on that field. And you know, these systems are being upgraded every now and then. So that is a matter that can be raised with the IT. Thank you.
Thank you. There's another question. Masi Kihungi, I don't know whether that has been answered. How and what are the proper forum for landlords where a tenant with 3 months arrears has been allowed to pay rent in installments without compelling the tenant to pay subsequent rent, but now the landlord wishes to evict the tenant despite the tribunal orders? Does the tribunal consider that the landlord is also in business? I think that goes to Honorable Gakui.
Yes, thank you so much. What I have seen in our tribunal is that even where a tenant has been granted interim orders of injunction against distress or eviction, landlords have been filing applications in the same cause to bring up the issue of non-compliance with the tenancy obligations. And ordinarily, we will actually order that both matters be heard together, so that at the end of the day, at the point of determination of the applications inter partes, you make an order on any outstanding rent arrears, as well as whether the injunction should be sustained upon hearing. In most cases, no member of the tribunal will actually confirm the order for injunction if the tenant is actually not meeting his cardinal obligation of paying rent. Number two, and we have heard it severally, is that even where there is litigation going on, nothing prevents the landlord from serving notice to terminate the tenancy in the pendency of proceedings on account of non-payment of rent under Section 7(1) of the Act, so that at the end of the day, the landlord's hands are really not tied. And finally, of course, unless there is a specific order for injunction against distress, distress is a remedy, and we have heard it severally that you do not need leave of the tribunal for you to proclaim property of the tenant for non-payment of rent. As long as there is some rent due, you can go under the Distress for Rent Act, so that at the end of the day, if the tenant runs to the tribunal and it is proved that indeed the tenant has outstanding rent, then that kind of a tenant cannot be protected. Otherwise, whereas we protect tenants from exploitation, eviction, and all that, we do not protect them against meeting the cardinal obligation of paying rent. Remember that we use the same principles that equity. He who comes to equity must come with clean hands. So in the event that a tenant has not met his obligation as such a tenant, surely there should be no basis upon which he can continue being protected by the tribunal.
Thank you, Honorable Gakui. Mukanzi.
Thank you so much, Effie. Maybe to note that we have received email addresses from Honorable Desmond Nungo on behalf of the Political Parties Dispute Tribunal. We have 2 email addresses. We have 3 phone numbers listed on the chat section. Equally, Honorable Hilary Korir has posted phone numbers to the Rent Restriction Tribunal, and equally an alternative number. Mheshimiwa, we shall be waiting for the email address and equally the same contacts from Honorable Gakuhi Chege.
Yes, I am asking for the contacts, then I'll share them immediately before we end the session.
Thank you so much, Mheshimiwa. I can see Honorable Korir has posted the email addresses to the Rent Restrictions Tribunal. Members, please take note of the contacts being posted on the chat section by our panelists. These contacts shall come in handy when you have matters on inquiries in the respective tribunals.
Mukanzi, if I may.
Please do.
Honorable Desmond, I have received a request from a member on the side, and they're asking, is it possible now that we are preparing for 2027, a number of young advocates logged into today's session were not admitted in 2022, and are asking, is it something that the branch and the PPDT can plan and have a more personalized training on what are the frequent challenges and mistakes that advocates do when they're filing these matters before the PPDT in preparation for 2027 to enable us get equipped and maybe get clients before the tribunal.
Thank you, Effie. Yes, we are open to further engagement with the lawyers on matters practiced before the PPDT on mutually convenient dates. So yes, we'll be happy to engage with the lawyers on the matter.
Thank you. And I hope the Secretariat are online and have heard that. We expect that we can take that up and do something for our members. I think there's no further question. I don't see any hand, and I hope no question is on the chat that has not been answered. We are just waiting for, okay, Honorable Gakui has posted something. Once we get that email and contact, Hesh, I think you've just sent email and contact.
Yes, I'm in the process of sending.
Okay.
In just a few seconds.
I think that answers Cosmas's question on technology. If Cosmas was waiting for you to add him to court, he would have been angry by now. But we understand technology is something that is we're all learning.
Especially for the old people like us who learned computer the other day.
We really understand. It is not only to the old people, it happens to all of us at a certain time. So as Honorable Gakui types, I think we can take the closing remarks from Honorable Nungo and Honorable Korir, and then Honorable Gakui will come last. You're on mute.
Sorry about that. I just want to take this opportunity to once again thank you all, right from the leadership of the branches, for availing this opportunity for us to speak to learned friends more about operations of our tribunals. And as I said, we look forward to more engagements. It was an interesting session. I think today it featured more on matters rent. I was appearing with the tribunals that deal with matters tenancy and rent, and I could see from the flow of questions that were coming up, and that's why we welcome that move to work towards a specialized one, because I believe that we would have been happy to engage more and have a more interactive session with the learned colleagues. But we thank you for now, and we also thank you, moderators Effie and Mr. Mukazi, for a very wonderful session. So we thank you very much. And to my colleagues also, just for the sharing. So otherwise, wishing everyone a good evening, and we look forward to more engagements. Thank you.
Thank you, moderator. Let me also take this opportunity to thank all the attendees for the fruitful engagement. I believe together we can overcome some of these challenges that we have faced for many years. And I believe the session today has been an eye-opener on the issues that we face and what can be done, both as branch LSK branches across the country can come together and push for the enactment of the bill, as well as the transition. The judiciary is still not complete because of the pending tribunal bill, which has also been in Parliament for far too long. So thank you very much and have a blessed evening. God bless.
Yes, allow me to join my colleagues, Desmond Nungo and Hilary Kolil, to thank you very much, Nairobi Law Society, Mombasa Law Society, for giving us this opportunity to also market our respective tribunals. Like you indicated, many of the tribunals are not known, and it would be a good forum to engage with the colleagues and also members of the public whenever we have these kind of sessions. How I wish that we can also extend it to include a few representatives like from the business community, and perhaps we could have this kind of an engagement for other stakeholders rather than for lawyers alone in different sectors. Otherwise, it has been quite educative also for me as a legal practitioner, because I am one. And indeed, we look forward to more engagement in the near future. May God bless you. Let's keep learning. Learning is important for all of us on day-to-day basis. Law Society, the moderators, and my fellow panelists, thank you so much for making this engagement a lively one. Thank you. Good evening.
Thank you so much, Honorable Gakwe. Lastly, allow me to bring in my co-moderator, Hetas Mukanzi from MLS.
Thank you so much, Effie. First, I want to appreciate the panelists for agreeing to be with us this afternoon. It's been over 2 hours of learning and relearning. We really appreciate your presence and your time with us. I also want to thank our members from both Nairobi and Mombasa Law Society for, again, creating time to attend the webinar and learn together. We appreciate your presence and also promise that such partnerships will continuously be explored in the future. I want to thank the leadership of LSK Nairobi branch and Mombasa Law Society for agreeing to move forward with this partnership. We thought it is better for branches to partner in initiatives like the one we've just had, as opposed to each branch doing their own activities and organizing same events as opposed to having them jointly. It breeds collegiality, saves on time, and it nurtures the bond that we shared all along from when we were in school to the times we've come to practice. And as I finish, I want to call upon the chairperson of LSK Nairobi branch to give his closing remarks, after which I will appoint my brother Amos Ndunda, as I said, member of the Water Tribunal, to move a prayer before we call it a day. Karibu, chairperson, Mr. Kivu.
Thank you so much, Brother Titus Mukanzi, Madam Welfare Effie Sheila. This has been amazing. I want to really thank the chairs of the different tribunals. I think the Honorable Gakui has said that we are marketing the tribunals, but maybe what you may not know is that you've done as a solid for the simple reason that now we have our members exposed to more areas of practice and avenues through which they can eke their livelihoods. And so I want to thank you for finding the time. We promise more collaborations. I have had Honorable Gakui suggest that we need to involve the stakeholders. Maybe we can plan it around the CUC's meetings so that we take advantage of the CUC arrangement to bring on board other stakeholders. The Honorable Desma, you have really supported the branch in many other forums. I want to thank you. Honorable Shari Korir, I also want to thank you for just being part of this and clarifying some of the things that have been confusing to our members. And importantly, our members, you have made this amazing Mombasa and Nairobi branch members. This has been a big success because of you. In fact, now to the members of Nairobi and Mombasa branch, you have caused other branches to accuse me, because I also happen to be the chair of the caucus, of just favoring, or rather of having Mombasa and Nairobi exclude everyone else. And so I have been tasked as the chair of the caucus to enlarge the collaborations with other branches. So Mombasa and Nairobi, Titus together with Effie, you now have a challenge to bring on board everyone else. And I think that is an amazing thing when people are happy about these kind of initiatives and they want to be part of it. It means that what Effie and Titus began just as a walk has grown, and it has become a movement that has taken up the entire LSK membership. And I want to commend you, Effie and Titus, for this particular initiative. We look forward to many more collaborations. We look forward to a lot of more learning together. I am happy. Thank you very much, members, honorable chairs. I wish you all an amazing evening. Thank you.
Thank you so much, Chair. Before I welcome my brother Amos Dunda to move a prayer, maybe, Chair, it's time I mentioned that together with my sister Effie Sheila, we are roping in the Southwest branch for a gym session next week in Nairobi, where members of the Mombasa Law Society will be coming to your city, yes, and members of the Southwest branch will equally be coming to the city. And we expect to meet members of LSK Nairobi branch at a gym that we shall announce later today for an intensive workout session.
Thank you so much. You know, the chair Southwest branch has been threatening me that you will not be able to match the energy from Southwest. So really, the challenge is to the members of Nairobi and Mombasa. The energy from Kisii and the areas around Kisii is not a joke. I look forward. I will be there. I will also take up the challenge and lead from the front. Asante.
Thank you so much. My brother Amos, kindly move a prayer for us.
Everlasting Father, we want to thank you this afternoon, Jehovah Father. We want to thank you for the gift of life, Jehovah Father. We want to thank you for the gift of good health, Jehovah Father. We want to thank you for all the good things that you continue to manifest in our respective lives, Jehovah Father. Jehovah Father, we want to thank you for the session that we have had. We want to thank you for the moderators that have carried us through the session, Jehovah Father. We want to thank you for the panelists that have enlightened us on various aspects to do with tribunals, Jehovah Father. Jehovah Father, we even want to thank you for all the participants that have participated in this session, Jehovah Father. Jehovah Father, we pray that this unique and this collaboration between the Mombasa Law Society, the LSK Nairobi branch, Jehovah Father, that it may continue. Jehovah Father, we even want to pray that this collaboration may be seen throughout the entire Law Society of Kenya, Jehovah Father. Jehovah Father, we want to thank you for the many blessings that you continue to manifest in our lives, Jehovah Father. Jehovah Father, as we are about to end this session, we pray for your care, for your protection, that you may keep us, Jehovah Father, until we see the next session, Jehovah Father. We greatly praise and adore your name, for there is no other name by which you must be saved, Jehovah Father. And in the mighty name of Jesus Christ do we believe, trust, and pray.
Amen.
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 If you can tell the member of God.
Have a lovely evening, everybody. God bless you.